Hi, my name is Dave Davidson. I'm a board certified health law attorney with offices in Delray Beach, Florida. Although I do have a statewide practice and represent some clients from out of state as well. I've been doing this since 1988, so maybe longer than some of you have been alive who are watching this. So I've been doing it a while. So hopefully I can have some experience and some worthwhile nuggets to share with you today as we go through negotiating and reviewing your employment agreements. I'm going to share a file with you here today as we go through. Contract review and negotiation. Let's talk about some preliminary considerations for you. To start off with, I think it's probably beneficial to address the two primary relationships that you may have with an employer. First is a W-2, that's an employee. You get a salary or some kind of preset compensation. You may get benefits like health insurance, paid vacation time, things like that. Taxes will be withheld from your income as well. And generally, at least in theory, there will be a little bit more direct control over your day-to-day functioning than there might be otherwise. Not in regards to your medical judgment, though, but in regards to policies and procedures and things like that in the practice. The second type is an independent contractor. In this situation, there's usually no benefits provided, no health insurance, no paid time off, things like that. And there's usually less control over your day-to-day functioning. Sometimes I think that's not necessarily the case, but that's the way the government views it right now. No taxes are taken out. You get a different form at the end of the year that shows how much you've been paid, and it's up to you to pay your taxes to the government. Regardless of whether you're joining a practice or whoever you're joining, employer, as an employee or as an independent contractor, the analysis that we go through today will still apply. So one way or the other, the general premises will be the same. Another preliminary consideration is for you to assemble your team before you start getting too deep into a potential relationship with a new employer. Yes, I recommend that you have a skilled accountant on board, that you have a skilled attorney on board, and then you may also have an asset protection or wealth management person or anybody else that you trust for advice in your career should be on board. You want to have a good, strong team so you're not in this on your own. And like I said, I recommend that the attorney you hire be somebody that has healthcare law experience. They may be a good attorney, even a good corporate or business attorney, or good employment law attorney, but without a little bit of health care experience, and the more obviously the better, you could miss things that need to be in your contract. I recently had a client come to me with an issue that they had used a very skilled, very well-known corporate attorney to help set up their practice. But the attorney had no health law experience and didn't realize that since there were non-physician owners to this practice, they needed to get a healthcare clinic license from the state. So they'd been in operation for about 3 years without the required license. So I do recommend that you have a skilled health law attorney on your team. So why do you have a contract? Well, it keeps things in order for everyone involved. It's going to tell you what you're going to do. It lets you know what you're going to get back in return for doing what you do. It's going to talk about the conditions that are in place governing each party, both parties, in order to keep things moving slowly. In other words, requirements of licensure, DEA registration, good, hospital privileges, things like that. It's also going to have some aspects similar to a prenuptial agreement, and that is going to talk about how the relationship can be ended, under what circumstances it can be ended, and then what happens afterwards, what clauses may apply even after termination of the agreement. It's very important to have a contract. I think it's not mandatory. It's not essential. You don't have to. There's not a legal violation if you don't have a contract. But I recommend that you have a contract because, especially at will states in Florida, without the contract, you can be just terminated at any time with no recourse. So it's good to have an employment contract in place governing the terms of your relationship. So the process is fairly standard as you go through it. There can be some variations to this, but this is generally what you can expect. Obviously, not on this list is the interview process. First, you're going to have phone calls or Zoom conferences or an in-person, hopefully an in-person visit where you can get to know the people that you're going to be working with and they can get to know you. Excuse me. So once you've gone through that and you know that this is somebody you would like to explore as far as being a potential employer, and they've decided you're somebody they want to consider as a potential employee, this is what happens. You may or may not get a letter of intent or a term sheet, and we'll talk a little bit about that in a bit, but you may or may not get that, which is just generally a non-binding outline of the terms of your employment. You'll then get a draft agreement that would anticipate being the contract that you would sign. That's basically their offer of employment. At that point, you would enter into the review and comment phase that you get your team members to take a look at it and give you their input. The way I like to do it, I will do my initial review and prepare a summary for my client that is generally fairly editorial or subjective, but it's a no holds barred analysis. So if I don't like the way the contract reads or there are things I don't like, I say that in this email because this is an email that's just between me and my client. It's not meant to be shared with anybody else. But if I don't like something or I think it's poorly drafted or I have any problems with it, that's where I'll say it in that initial analysis. I'll then take time, set up a time with my client to sit and talk to them about all the issues that I've raised and the things that I've pointed out to see if they share concerns, if they have additional concerns, if there are things that should be in the contract that aren't in the contract that need to be there. We'll then refine my no holds barred email into a letter that's a lot more easier to swallow, that says these are the things we'd like to be changed. And then that document is what gets given to the potential employer. You don't want to share the initial email because sometimes, even though it's coming from me and not from the client, it can be off-putting, to say the least, to the potential employer. So we present that analysis to the employer, and then any negotiation goes back and forth. They may say, fine, that's a good point, we'll make that change. There may be things that aren't addressed in the contract that you want to have in there that will use that point to say, hey, can you add this section as well? And then after you beat up the contract back and forth a little bit, you come to an acceptance and a meeting of the minds, and it's time to execute the contract. So that's the way the process generally goes. So where do we start? What are the first steps? Well, the first thing I recommend is that you know your potential employer. One of the reasons I recommend that is because they're going to know you. They are going to do their own background check on you. They're going to check your social media and postings and things like that to see what they can find out about you. But obviously, they're also going to check your your personal and professional references that you give them. So, I recommend that you know who it is you're contracting with, because a lot of times you may rule somebody out just based on what you find out there. There's multiple options in identifying your potential employer, and each one of those will have kind of a different structure in the contracts they give you. If you're contracting with a hospital, that's going to be a standard employment agreement with a salary and bonuses and things like that. One thing to remember is you will never be the owner of the hospital. You'll never have equity in the hospital. So there's a lot of safety in hospital employment. There are some people that absolutely love it. And so I don't have any problem with clients who are going to work for a hospital. But the employment structure may be a little bit different there. You'll also have, you may be joining an individual in a practice, or you may be joining a solo practice. In that case, you'll have an employment agreement with a salary. And then, there is a possibility that you'll have equity someday in the practice and you'll become an owner. And that's the same thing with a professional group as well, the larger group situation. You'll be an employee. It may be a little more complicated the bigger the group is, but there's still opportunity to address ownership at some point in the future. You also want to know, you may be joining a practice that's owned by a private equity firm or an investor-owned group. Definitely something you want to know. It's also important to know if you're joining any of these other groups, the individual solo practice or a large group, whether or not there's a potential that they could be acquired by a private equity firm as well. Not that there's anything negative to that, but certainly you don't want to join a group that has a strong down-home feel, and all of a sudden the next day there's a new set of policies and procedures you have to follow with the private equity group. So it's something you need to be aware of. Note with private equity, this may not be the opportunity for you to become a shareholder or an owner partner in the group under those circumstances either, although there may be opportunities for you to be an owner in a management group or something else that's involved with the private equity structure. Another potential is if you're just hanging out your shingle on your own, you may not need an employment contract then because you probably trust yourself enough, but you may want to start an LLC that actually runs your practice. And in that case, you would become an employee of the LLC, or could become an employee of the LLC. Maybe the most important thing to think about in these situations is reputation and structure of your potential employer. Reputation is very important because it will say a lot about, if you join the right group, it could say a lot about you in a negative way that could impact you later on. So do your research, find out the reputation of your potential employer. So you've started the process, you like them, they like you, they possibly will give you a letter of intent or a term sheet. This is just a non-binding summary of the relationship that the parties anticipate entering into. One thing that I say with term sheets is make sure if there are key points that you want addressed in your employment agreement, make sure that they are in the term sheet, because even though it's not binding, people will circle back to it. So if you've told them that, I want every third Saturday off, and they've said, oh, sure, that's not in, there's no problem, and you get a term sheet and that every third Saturday is not in there, go ahead and put it in there, because later when you get the contract, if it doesn't say you get every third Saturday off, they'll go back to the term sheet and say, well, that wasn't addressed in the term sheet. So make sure you have that in there. But it's just a general overall summary. Although sometimes they can get long, it's just a general overall summary of the anticipated relationship. So then you get the contract. the actual contract itself, which, could be, I've seen some that are one pagers. The one page ones make me nervous. But, it could be 10 to 20 pages long. Don't let the volume of it scare you away. The basic important things you'll find in the employment contract is what, which addresses what you're expected to do under the contract, when you are expected to do it, and where they want you to do it. All of these are very important. The what is probably going to be practice medicine and other related administrative duties to it, but there could be some other things in there. The when is important because you want the contract to at least have some indication of what your anticipated hours are going to be, what the call coverage responsibilities are going to be. If you're joining a group of 3 other doctors, you want to make sure you're not handling 100% of the call coverage, and things like that. So you want to know when you want to do it, and you want to know where they want you to do it. If you're just joining a group with one location, that's probably not going to be an issue. But I've had clients that have joined statewide employers with contracts that have zero specificity of the locations where they're going to work. That could be problematic because if you've set up shop down in Miami-Dade and they suddenly tell you, well, they need you to staff the Pensacola office, that could be a problem. And unless the contract is specific to that, then you may be in breach of the contract if you turn that down. So those are the general terms of the contract. But maybe the most important thing you want to talk about is the compensation. There are any number of ways that compensation can be structured, and there are any number of ways that compensation can be negotiated. Sometimes it's not negotiable. Sometimes they'll tell you, if they've got a bunch of physicians that are in the same position as you, they may tell you, what, that's what everybody gets. That, the doctor we hired last year is getting paid that and in that manner, and that's what we're going to pay you. But it's important that you're comfortable with the level of compensation, and if it's not sufficient, that's something that needs to be raised in the negotiation process. As you go through, and especially if you're joining a large group or a private equity held group, or especially a hospital, you're going to hear a bunch of new terms thrown around, and they may not be brand new to you, but you'll hear things about the Stark Law that, and sometimes these terms are used as negotiating tools, but they are legitimate regulatory issues that exist with compensation structures. Again, hospitals are the most sensitive to this because you will be referring your patients to the hospital that is also your employer. So it is something of a minefield for hospitals to negotiate. So I'm not downplaying the significance of these, but a lot of times they'll be used in negotiations, especially with salary, and to say, we can't pay you more than that, or we can't do more than that. The first one is the Stark Law. That's the prohibition against self-referrals. Physicians can't refer patients to facilities or entities in which they have an ownership interest. There are multiple exceptions to the Stark Law, so both your lawyer and your employer's lawyer will need to make sure that you fit into an exception if you're going to be referring patients, either not just hospitalization, but for any of what's called a designated health service. That can be imaging, physical therapy, DME, things like that. So you hear references to the Stark Law. You'll hear references to the anti-kickback statute, which is basically the federal law that prohibits money being paid for referrals. Again, there are safe harbors associated with the anti-kickback statute. So you'll need to make sure, or your lawyer will need to make sure that your proposed agreement fits within safe harbor of the anti-kickback statute. Note that there are also state counterparts to these laws. All 50 states have their own version of the Stark Law and the anti-kickback statute that prohibits self-referrals and payment for referrals. So you need to be aware of those. And then you'll hear the term fair market value. Again, especially if you're joining either a private equity held group or a hospital, they will throw that out and they will say, we can increase your compensation because if we do, it takes you beyond fair market value. And that's legitimate. The legal term of fair market value is basically a negotiated price between two parties at arm's length. But the government sees it as a little bit more of a black and white concept. So hospitals, again, to avoid government scrutiny, do have to make sure that the compensation they pay you fits within fair market value. Excuse me. But like I said, sometimes they will use that concept to refuse to increase income. We're dealing with a client right now that received a very low salary offer, what we felt was a low salary offer from a potential hospital employer. From everything we saw, in the surveys and the research we did, the salary could have been higher, but they were saying that was the max they could offer based on the fair market value report that they received. Interestingly, when we asked them to share that information with us, they said no. So it puts the doctor in a tough position. The hospital's telling you, our reports say we can't pay you more than what we're offering, but we're not going to share our reports with you. So it's time to consider whether the salary that's offered, which is now kind of a take it or leave it situation, whether that's sufficient or not, or whether the physician needs to start seeing who else is out there. Compensation structure can be done in a number of ways. Most of the time we see a guaranteed salary unless you're doing shift work, and then sometimes you'll see payment based on the number of shifts that are worked. But you'll see, at least an initial base salary being offered. Sometimes even in first brand new contracts, we'll see an eat what you kill structure. In other words, your salary is entirely based on your collections. Most of the time for brand new physicians, there is some level of a guaranteed draw at the very least, if it's not, a guaranteed salary. So you'll have a flat base, and hopefully there'll be some mention of annual increases, or if not annual increases, at least an increase at the end of the initial term, because sometimes the initial term might be 2 or 3 years. But you want to, make sure that there is an opportunity for increases, not necessarily telling you what the increase will be, but at least telling you that increases are on the horizon. Also, frequently there will be an opportunity for bonuses above and beyond your base salary. If you're joining a group, that's usually based on what your collections are. In other words, once you hit a threshold of collections, you'll get a percentage of the collections received beyond that threshold. And sometimes that can vary as you pass secondary and tertiary thresholds in the amount of collections for services personally performed by you. If you are working for a hospital, your bonus is probably more likely going to be based now on your work RVUs, because again, it's easier for the hospital, should they come under government scrutiny, to say, we bonused this doctor based on the amount of work they actually did, regardless of collections. Now with hospital folks, sometimes that's beneficial, because when you're based on RVUs instead of collections, your uncollectible accounts, your charity care, your charity patients, your indigent patients will all still be calculated towards your bonus, because your RVUs for those folks will still be calculated, when if it's just based on collections, they won't be. A lot of times hospitals, though, will also put a cap on your salary. In other words, they'll say, this is your base salary, this is your bonus opportunity, but in no extent can your salary go beyond a certain number. Again, they've done that so they don't exceed the parameters of fair market value. I understand why they do that. I'm not a fan of that because in theory, if you are working really hard and your RVUs exceed that cap with your bonus opportunity, you shouldn't be penalized. Generally, hospitals don't like taking that out if it's in there, but it's something to be aware of and for you and your team to discuss as to whether or not that's acceptable or not. The contract will also frequently talk about outside activity. The thing you want to know there is, first off, whether it's permitted, and if so, do you need advance permission? And then if you are going to do outside activity, either moonlighting or legal reviews or utilization reviews or things like that, who gets the money? If you're doing the outside activity, are you able to keep the funds for that, or does all of it get turned over to your employer? Most of the time you're allowed to keep it, but sometimes the contract provides otherwise. Another thing I need to hit now in the midst of our pandemic is that you may see, or you most likely will see, a pandemic clause in the agreement. Those cases allow for adjustments to salary, possibly benefits, possibly to workload in response to the pandemic. There are a lot of contracts that didn't have that kind of clause in them. And in 2020, suddenly there were a lot of breach of contract provisions or lawsuits filed because employers had breached the terms of their contract. So now most of the time we're seeing pandemic clauses or act of God clauses or force majeure clauses that say, in the event of something that's out of the employer's control, we reserve the right to make changes to the contract. As long as you trust your employer, that's going to be fine. They're going to be in there. In addition to compensation, your contract will talk about benefits. Benefits are not required even with an employment relationship, but usually some level of benefits are provided. These usually aren't locked into the contract. It may say they provide health insurance, but it will say that subject to the employer's plan. So if you start in there with Humana and you really like the Humana plan, that doesn't mean the employer can't switch to Aetna the next year for whatever reason, save money or coverage issues or things like that. So benefits, even though it says you get them, there's probably going to be a clause in there that says it's subject to the plans that the employer holds, and that's fine. There is, unless it's mandated in your contract though, there's not any legal requirement that an employer offer benefits. The most typical and most common ones are health insurance for you, for your family, participation in a retirement plan, time off for vacation, sick time, continuing education, and then the provision of malpractice insurance. Most of the contracts I see have those addressed some way or another. Less typical, but also not uncommon ones are signing bonus, moving expenses, participation in a life insurance policy, participation in disability, a car allowance, cell phone allowance, and things like that. Sometimes the benefit provision is extremely generic and just says, as an employee, you're entitled to participate in all benefit plans that the employer offers to its other employees. And that's fine. But if that's the case, make sure you get a list of what those benefits are, at least at the time of execution, so you kind of know what to expect. Because otherwise it may just be the generic form and they tell you that all they offer is, well, after you've signed up and you say, all right, well, tell me, about this health insurance. It's like, oh yeah, we pay you $25 a year to offset your health insurance expenses. So if you have a very generic clause like that, find out from them, get more details on what those benefits are. So the ones that are important to you are appropriately addressed. Or if they're not addressed, that, if there are health insurance concerns and they don't provide health insurance, you need to be able to see what the cost is going to be for you acquiring that on your own. Most likely, your lawyer will also flag that in the contract review. Talk a little bit about liability insurance, which is, like I said, another benefit that's frequently covered. If you're an employee, 99.5% of the time, it is going to be in there because an employer is responsible for the acts and omissions of its employees. So the liability insurance provision will be in the agreement. Independent contractors, it may vary, but usually the independent contractor is going to have to be responsible for acquiring liability insurance on their own. But regardless, the contract will probably set out the amounts they expect you to cover. In Florida, generally, the requirement is $250,000 per claim with a $750,000 maximum payment per year coverage. If you have hospital privileges, that is the minimum amount that's required by law. If you're not practicing in a hospital, it's not that high, but generally $250,000, $750,000 is what's required. You may have an employer that requires or provides $1 million, $3 million in coverage, and that's fine as well. I don't mind the $250,000, $750,000 coverage. Some people don't like that, but I think that's sufficient protection of your risk. The contract will also most likely touch on tail insurance requirements. This is what applies should you leave your employment. You want it to say who buys the tail insurance and under what circumstances. Probably most of the contracts I review still have the employee paying for tail coverage when they leave. More and more often now, I'm seeing more of an equitable requirement as far as tail insurance goes. And in fact, it's what I recommend to my employer contracts when I'm drafting the employment agreement for them. And what I like to see is the tail insurance requirement be tied into the circumstances of the end of employment. So if the employee, which is you, if you terminate the agreement for cause, in other words, the employer has breached the agreement, or if the employer terminates without cause, meaning that they're terminating you even though you didn't do anything wrong, then I think the employer should pay for tail insurance because they are entirely responsible either through a breach or a unilateral decision in terminating your employment. However, conversely, if the employer terminates the agreement because you breached the contract, or if you terminate the agreement without cause, in those circumstances, I think it's fair that you pay for the tail insurance. Sometimes employers won't budge on this. Sometimes they are willing to listen. It's hard to argue against my proposal as being fair, but sometimes they will say absolutely not. And there are some times that the employer doesn't even want to fight over tail insurance, and they just say that they're going to pay for it and continue it. In those cases, then that's probably the best situation for you. Finally, there was probably also, you want to see an indemnification provision in there. In other words, that they protect you, and conversely, you protect them for any losses that you might suffer arising out of your employment with them. Another thing I like to see in at least the non-hospital employment agreements is a partnership track. Doesn't need to be very detailed. It doesn't need to have what your purchase price is or anything like that, although I do see that sometimes. But it should at least set a reasonable expectation that you're going to have the opportunity to become an owner of the employer, of the practice, and the promise of a future conversation. I don't, if that's all you get, that's fine with me. I think that's all you can really hope for, is that they say, you know, for example, at the end of 2 successful years of employment, we'll sit down and talk about terms of you buying into the practice. I do have a couple clients that employer clients that specifically say what the purchase price will be, and almost guarantee that the physician will become a partner after 2 years. I don't really recommend that because if you're hiring somebody who may be a good doctor but is a jerk, you may not want them to say, hey, whether you like it or not, I'm now your partner. So I think it's best for both parties if it's just a reasonable expectation that you're going to, at some point in the future, talk about what it's going to take to get you into being a partner in the agreement. Now, all those are the terms that are kind of good terms, pleasant terms to talk about. There will be some negative things that we got to look for and how they're addressed in the contract. The first is restrictive covenants. These would be non-compete clauses, non-solicitation clauses, and confidentiality clauses. Working from the bottom up, as far as the complexity, confidentiality, that pretty much is self-explanatory. As an employee, you're going to learn some trade secrets and some sensitive business points and information from your employer. So they're going to want to make sure that you don't share that with anybody else, that remains completely confidential. So that's pretty standard. And usually is not objectionable in the way it's drafted. The second one there, non-solicitation, this is a clause that's going to keep you, after the agreement is terminated, from soliciting employees or contractors or patients to stop or terminate their relationship with the employer. That usually has a time period attached to it. Generally no longer than 2 years is enforceable in Florida. There's all kinds of wiggle room in here. The group may not care if you take patients with you, but they don't want you taking employees, or vice versa. So it could be all over the spectrum, but basically it is to protect the integrity of the practice, that you can't solicit their business relationships either through employees, contractors, vendors, or patients away from them when you leave. And then the first one is probably the one that causes the most heartburn, maybe not when you're signing, but when you're trying to get out of the agreement, and that's the non-compete clause. States vary on how enforceable these are. California does not like them at all. But most states will enforce them as long as they are reasonable in both their duration and in their scope. So, for example, in Florida, any non-compete clause that lasts longer than 2 years will not be enforced beyond the second year in Florida. Florida courts, Florida law has set 2 years as the maximum reasonable amount to keep somebody from working in a specific area. And then speaking of area, it has to be reasonable in scope. In other words, if you have if you're joining a group that has one office located in Palm Beach County, Florida, you're a non-compete clause that keeps you from working anywhere in the state of Florida is probably not going to be enforced in any court in Florida. Now, they may enforce it in regards to Palm Beach County, maybe Martin or Broward, possibly, but not statewide, because the court's going to say that that's not reasonable. A practice with one location in Palm Beach County doesn't have a reasonable business interest in the Panhandle sufficient to prohibit you from taking a job in Pensacola. So it has to be reasonable in duration and reasonable in scope. Most of the time you see it either as like a 10, 25, 50 mile radius of the place where you are providing services. But note that there are employers that have a statewide footprint. There are urgent care companies that have offices throughout the state. And the court may tell them you do have a reasonable business interest throughout the state of Florida sufficient to keep a doctor from working in the state. The scope of your practice sometimes comes into play there too. I have seen restrictive covenants that prohibit a physician who practices in a specialty, that's for just hypothetically gastroenterology, from practicing medicine within a radius. So the restrictive clause will say, for a period of 2 years, the employee, despite the fact that the employee is only practicing gastroenterology for the employer, can't practice any type of medicine within the geographic region set out in the contract. I've seen some courts enforce that. Some of them don't. Most of the time they say, if all you've been doing for the employer is practice gastroenterology, the fact that you are also board certified as an internal medicine physician you shouldn't be prohibited from practicing primary care internal medicine if you choose to change the scope of your practice. I've seen it go both ways in enforcement, but it's something to take note of when you're looking at the restrictive covenants. The other less desirable thing you'll find in the agreement is the termination clauses. The agreements can always be terminated mutually if both parties agree that it's not working out. That's usually, it's rare, but it happens sometimes that both of them say, I like you, but it's just not working out, and we're done. That you may or may not have a mutual agreement clause in your contract itself, but under the law, both parties can agree to that, whether it's in there or not. But you will have other clauses in the agreement that govern termination. The first is immediate termination. This is usually tied to your ability to practice medicine. If you lose your license, if you are excluded from Medicare, those are usually grounds for immediate termination, because as of the date of that occurrence, you can't practice medicine anymore. So you will be, you could be subject to immediate termination. Sometimes there'll be other things that would give cause for immediate termination, like an arrest or some kind of fraud or things like that. Personal malfeasance may also be cause for immediate termination. There may also be a termination clause that allows for termination with cause, but gives an opportunity to cure. So For example, if you are moonlighting for a competitor and your employer finds out about it, they may say you've got 10 days to stop that or we're going to terminate it. So they give you time to cure your breach of contract. Or if, for example, if you're not completing your medical records on time, and that's a clause in the agreement, in your employment agreement, that you'll complete all your records in a timely manner. If you're not doing that, they'll say you need to get better. You've got 10, 15, 20 days to get better. And if you don't get better, then we're going to terminate you for cause. But they have given you the opportunity to cure that problem. Similarly, you may have the opportunity to terminate the agreement for cause with a cure as well. So for example, if they miss a payroll for you, you can tell them, look, you got to pay me within 10 days or I'm terminating for cause. So that's usually, both sides have the opportunity to terminate for cause with a cure period. And then I also recommend that there be a termination without cause provision in there. And most of the agreements that I draft and most of the agreements that I review for clients have that kind of provision in there. That basically says that either party can terminate the agreement without cause with something like 90 days advance notice. So you give notice and say, please be advised that in 90 days, I will no longer be an employee here. I like those because it gives you the opportunity to get out of an uncomfortable or untenable situation, and it gives the employer to terminate without cause as well, to get out of a situation or an employment arrangement that they don't like without ruining somebody's reputation by terminating the agreement for cause. So I like having them in there. Sometimes they're 90 days advance notice. Sometimes it's 120. Sometimes it's even longer. There's no legal requirement that it be either a short time or a long time. 90 days seems to be the most common, with 120 probably the next common. Occasionally I'll see 30 days or 60 days, but when it's that short a time, it doesn't really give you time to find a new job if they're terminating. And likewise, it doesn't give them much time to find a replacement for you if it's you the one given the notice. Sometimes you'll also, as part of the termination without clause provision, see that the employer has the right to discontinue your provision of services right away, even though they still have to pay you for the full 90-day or whatever the termination notice time period is. That's fine. It's legal. I don't know if it's fine or not. Sometimes it's not great for patient care or care continuity, but they note that sometimes those provisions are in there. So you give your notice and say, in 90 days, I'm not going to be working here anymore. Your employer may have reserved the right to say, look, go ahead and stay home. We're going to reassign all your patients. Not much, if it's in the contract, there's not much you can do about that. But it does free up time, as long as they're still paying you, to go find another job if you've not found one yet. So overall, although there are negative aspects to a termination without cause provision, I generally like them. Another thing that I don't have here as a bullet point is the situation with auto renewal of a contract. Most of the time, the contract will say, this contract is effective on such and such a date, and it will terminate, after a year or 2 years or 3 years, and thereafter will automatically renew for 1-year periods. I like the auto renewal provision because it always makes sure that you are working under the terms of contract, because if the contract doesn't automatically renew and it expires, then you become an at-will employee for the most part, and you don't have any structure that the employer has to work under. So I like the auto renewal provisions, but there's usually also a provision that says that if either party doesn't want the contract to auto renew, then they have to give 60, 90, 120 days advance notice. Otherwise, you're stuck with the auto renewal. So if you are thinking about leaving employer and you don't want to do a termination without cause and you just want it to lapse, make sure, or you don't have termination without cause available, make sure you're aware of when that window closes as far as advance notice to stop an automatic renewal. And then I think the last thing I want to talk about is things that are in the contract that are not in the contract. And those are the hidden terms or the hidden figures. And that's a clause that says incorporated herein by reference. That's not uncommon to see in a contract, and it's absolutely legal, but it's something that you need to consider, because anytime you see that language incorporated herein by reference, whatever it's talking about is actually part of the contract, even though it may not be physically written in there. So if the practices, policies, and procedures are referenced and incorporated into the contract, or if the practice or hospital's compliance plan is incorporated into the agreement, those are all parts of the agreement. And if you breach a policy and procedure, or you breach part of the compliance plan, you've effectively breached your contract, and then they may have the right to terminate the agreement or give you the opportunity to cure the breach before they terminate it. So always be aware of what's incorporated herein by reference. And note also that if you're joining a religiously affiliated health system or group or hospital, they will definitely have a link to their own religious standards as well. So the Catholic health systems, the Baptist health systems, the Adventists all have their standards that that you need to comply with as well. And if you don't comply with those, again, it could put you into a situation where you've breached the agreement via something that's only incorporated into the agreement rather than specifically spelled out. So when you see that, the point is, get them. So if policies and procedures are incorporated, if compliance plans or religious or faith tenets are incorporated, get them. Now, fortunately today, most of your potential employers are going to be able to provide a link to those and say those standards are here at this link, or policies and procedures, compliance plan, or at this link. So you can click the link, take a look at it, and make sure that there's nothing in there that either you can't comply with or you have questions about. Because even though they're not in the contract physically, they are in there. Just as an aside, I had one client who literally had a 2-page employment contract with a very big healthcare and well-known healthcare system. But her contract was 2 pages. So she needed me to take a look at it for a couple issues that had come up. And when we tallied everything that was incorporated by reference into the agreement, it was over 1,000 pages. So even though the 2-page agreement may look short and sweet and simple, odds are that it's not. So with that, I think you have a good foundation on the process of contract negotiation, what points you really need to pay attention to, what points that your cabinet of advisors, your team, will touch base with you on. Obviously, it's important that you follow along with your professionals and take care of all your concerns to get a comfortable contract and a successful career with your new employer. With that, I'll stop. Hopefully this has been helpful, and I hope you have a terrific day.